The facts of this matter are as follows. This is a mortgage foreclosure action based on a note and mortgage that were entered into between River City Real Estate LLC and Woodlands Bank on or about February 18, 2008, with respect to 13.056 acres on Ladies Island. Mr. Gessie executed a guarantee of obligations of River City in conjunction with the loan transaction. The maturity date on the original note was extended and renewed by Woodlands Bank 4 times from November 20th, 2008 to April 20th, 2010. On July 16th, 2010, Woodlands was closed by the Office of the Thrift Supervision, and the FDIC was named a receiver, as I said previously. On July 16th, that same day, the assets of Woodlands Bank, including the note that River City had given to the bank, were purchased by the plaintiff.
Quite frankly, the bank, in its infinite wisdom, never alleged something that you have to allege in any contract action, which is compliance with conditions preceding. That's not in their complaint. A note is a contract. A mortgage is a contract. And the reason it's not in, I'm going to assume, is because they knew they didn't comply with conditions preceding. In South Carolina, mercifully, we have 2 implied covenants. One is the implied covenant of good faith and fair dealing. The other is the implied covenant that one party will not hinder, prevent, impair, impede, delay, or preclude the performance of the other party. Those covenants, by our law, are both conditions as well. They're conditions preceding, and the bank violated both of them. And I'm not talking about Bank of the Woodlands, I'm talking about these gentlemen in their current manifestation, that is Bank of the Ozarks. Consequently, to take them in order, the fact that Mr. Gessie and River City did not deny anything sought in the request for admissions means that they adhered faithfully to what they said in their answer, which was, we admit we signed the documents, we admit mostly the documents say what you think they said. However, we have this little problem with the documents, and that is there are these implied covenants and conditions, and you haven't complied with them. And that's what the implied covenant of good faith defense that appears in Mr. Fairbank's answer on the behalf of River City and Mr. Gessie is intended to develop.
Woodlands is not a plaintiff in this action. Woodlands was taken over by the Office of Supervision of Thrift. The FDIC was appointed receiver. The assets were sold to Bank of the Ozarks. The shared loss agreement is irrelevant in this foreclosure action. Mr. Matheson said that they wanted to force a default as soon as possible. There were 4 extensions to this loan over a period of 3 or 4 years. He says that Mr. Gessie and River City's performance was delayed or prevented, but not by Bank of the Ozarks.